Discuss the purpose of evidence. In the American justice system, evidence is the most important. Evidence is important that people can base decisions. In the courtroom, the jury can hear and see evidence during a trial and see the rules and called laws of evidence. This evidence is presented during a trial, and the courtroom enables the judge and jury to decide the case brought before them. The evidence and testimony and physical items are presented to the judge and jury so they can be determined the truth of affirmation. The evidence must be emphatically understood and arguments settled by the jury. Ultimately, evidence is used to prove guilt and innocence of an accused person with the jury. Their final decision is based on the facts of the case, and their decision is based on the evidence presented that can prove or disprove what the jury believes to be facts. Sometimes during court case there might arise additional evidence that comes into court for presentation in the jury, such as weapons for the crime, contraband. Additionally, evidence could be bloodstains, latent fingerprints, plaster case, shoe imprints that did not appear in initial investigations. The majority of all evidence before trial is kept safe in the evidence room or locker. The evidence is logged and tagged with the date and the booking incident report number of the offense. The evidence can be checked out of the evidence locker by a prosecutor or a defense attorney for examination. Legally, any items found to not be evidence until they are introduced in court proceedings and become exhibits. No item of physical evidence can be introduced at trial unless the law enforcement officer has maintained a proper chain of custody of the item. Evidence may be classified in three different ways. They are real or demonstrated, direct or circumstantial, physical or tangible. That's a little more than three. Okay, next is describe the general process and handling of all evidence from time of discovery through disposition. One crime has been committed. Police officers, investigators, detectives will tape off the crime scene to prevent tampering. Evidence is collected and prioritized in order of size. Large items of evidence can be collected first on down to trace evidence. Once the smaller trace evidence is collected by way of vacuuming, taping, tweezing, and taken to the lab for analysis, these items of evidence also include hair and blood samples, bullet casings, dust of fingerprints. At the lab, they will be detailed examination and the elements and the structures of items, discussion for interpretation. They're looking at the trace evidence, body fluid sample of blood, DNA analysis, blood spatter patterns, hair, fibers, fingerprints, powders, and chemicals, casings, bullet casings, footwear, clothing, and any firearms left behind. Some of this evidence must be preserved while others do not. Evidence is logged and tagged and date in the booking and incident report number of the offense. It's the responsibility of the Attorney General and other local, state, and investigators to preserve the evidence. Is also include the prosecutors. Most of the evidence that must be preserved are the items that play a significant role in the suspect's defense, such as materials and expository evidence. Once all evidence is in the evidence locker, it can be checked out by the defense prosecuting attorney for examination. This is the time of discovery if the defendant pleads not guilty. At this point in case it's set for trial right away, these attorneys will file papers for trial. This usually pretrial motions to test the waters of legality used in the search and seizures, changes in venue. Before trial, the exchange of information begins discovery. There is set time for pretrial motions, usually to be filed 2 weeks to 10 days of arraignment. Next, name and the described types of evidence. The basic concepts of evidence used in American legal system are relevancy, material evidence, prima facie evidence, as well as contradictory and collaborative evidence. Also, there is judicial notice, where the judge takes certain statutes, geographical facts, definitions, word phrases, and abbreviations, notice, date, and time, scientific and medical facts, without having experts having testified to authenticity. Evidence can be categorized into 4 headings. 1, testimony of witness; 2, real and physical evidence; 3, documents or writing; 4, demonstrative evidence. There are other ways of categorizing evidence: direct evidence, where the witness testimony and the jury need not draw an inference in order to find facts to exist, are sometimes used. There is also circumstantial evidence, evidence from which inference must be drawn from the jury to find the facts to exist. Each of the categories of evidence have their own importance and unique function to deal with the facts during trial proceedings. Relevant evidence is defined as evidence that is making a fact seem more or less credible than it would be without evidence. Material evidence is defined as proof of testimony in significant relationship with the facts and issues of the case or inquiry that affect its conclusion or outcome. Testimonial evidence is defined as a statement made under oath, also known as direct evidence or prima facie evidence. Prima facie evidence is defined as evidence that is standing alone, unexplained, uncontradicted. It is satisfactory enough to establish given fact or a group of findings constituting a party's claim or defense. Next, dismiss the admissibility of evidence. Admissibility evidence is any document, testimony, tangible evidence used in court of law. Evidence is usually introduced to the judge, jury to show the point, prove a point in case. Judicial notice is defined as an acknowledgement of the fact that judge, without explicit confirmation in the form of testimony and tangible evidence being presented. It is a substitute for evidence. If the judge is asked to rule on admissibility of evidence before a trial is called a motion of limine. That's L-I-M-I-N-E. The reason for this ruling is to prevent inadmissibility of evidence from contaminating the jury. Once the court has a definite ruling, the party does not have to renew an objection or give any proof to show ability of the claim, an error, or appeal. The admissibility of the piece of evidence, there is a standard of renewing the ability of evidence, admissibility of evidence, though. They are technical rules of evidence. They are like the hearsay rule, which a judge may consider any non-privileged information regardless of whether that underlying information would be admissible. And the question is weighed using the preponderance of evidence standard. There is also conditional relevance determinations. For conditional relevance of the court has only to consider evidence that would itself be admissible and make its decision based on whether a reasonable jury could find the condition fulfilled. Admissible evidence must be used to win a case that proves the defendant's guilt beyond a reasonable doubt. Relevant evidence is defined by FRE 401. For that evidence to be admissible in court, the evidence has only to show existence of the fact that the consequence more probable or less probable than it would be without the evidence. Evidence is not relevant, is not admissible. However, relevant evidence can be inadmissible. If the evidence has no logical relevance, the evidence could be excluded. If evidence seems prejudice or agitates the jury, it could be excluded. If evidence is shown to the jury to be confusing or cause many ways of thinking of the issue, it could be considered a waste of the court's time and most likely to be excluded. Next, describe the nature, purpose, and legal framework of privileged information regarding evidence. There are special circumstances which a person could have special information, that evidence is considered privileged and the information is protected, and the holder does not need to testify. Most likely the person is a confidential relationship in the United States. These relationships are secrecy and encouraged and protected. By removing the fear of exposure in court, the law promotes the relationship. When evidence is protected in this fashion, it is called privileged communications. Sometimes in these situations, important relevant information is excluded from trial. Recognition is being considered privilege. With the policy of law, it considers that privileged information involve benefits, both secrecy outweighs any benefits that society would derive from disclosure. These privileged relationships are strictly limited as they block information from coming to truth and prevent full disclosure. Justification and exception of the general rule against privileges must be for the public good. There must be a strong public interest in fostering the relationship in order for the privileges to be recognized in the law of evidence. Fostering relationship privileges are based upon reason. Let's say a priest would not discuss information whether or not they exist a privilege because the rules of his church prohibit disclosure. If there is no attorney-client privilege, a lawyer has the duty to zealously represent their client, might feel compelled to lie in order to fulfill the duty of zealous representation. Relationship circumstances giving rise to privilege are therefore limited to and unique. There are 4 fundamental conditions that must be established before a person is exempted from testifying in a judicial proceedings based on the claim of privilege. 1 is confidential communication will not be disclosed. 2, the confidentiality must be essential. 3 is the relationship is in the opinion of the community to be promoted and protected. And 4 is the injury that would cause the relationship if disclosure of the communications is to be greater than the value of the conversation, proper resolution of the court case. Other privileged information with regards to evidence involves special relationships are husband and wife, child-parent privilege, attorney-client privilege, physician-patient and psychotherapist privilege, clergy privilege, and others. Not all are recognized in all states. Next, disclose the legal proceedings for securing admissions and confessions. The law of evidence, as it relates to statements, may be accused in a criminal case commonly known as the opposing party statements and admissions and confessions. There are certain conditions under which confessions are constitutional. There are certain rights the police must provide the accused before any statements can be taken. One is the Miranda rights in which they must read the defendant before questioning. Another, the Sixth Amendment of the U.S. Constitution guarantees right to counsel. Sometimes confessions and admissions frequently overlap, and it is difficult to decide if the statement and the admission are a confession. It is said the confession is an admission of crime itself, while the admission concerns only with the specific fact that in turn tends to establish guilt or some element of the offense. It would define the admission as out-of-court statement tendered to the truth and its contents that to advise the interest of the maker is admitted because it is reliable. I would define a confession as it is an admission of guilt that goes directly to culpability by way of words or conduct. For a confession to have been freely and voluntarily made, the person making the confession must be in the position to exercise complete mental freedom at the time the confession was made. The courts have been strict in their interpretation of what affects the complete mental freedom and ruled that pressure applied to introduce confession will be considered as an interference with mental freedom and cause a confession to be excluded from evidence at trial. The requirements that the confession must be freely given and voluntarily satisfies 2 concerns of modern jurisprudence, excuse me. 1, unless confession is given, there is no doubt about the fundamental fairness used in trial against the accused. 2nd, unless it is given freely and voluntarily, the accused's rights against self-incrimination may be violated. Statements or acts by the accused before trial are not an acknowledgement of guilt, but do link the accused to the crime in some ways, incriminating or admissions. The accused need not intend to incriminate himself or herself in a statement or act by admission. By an admission made by a simple acknowledgement of being at the crime scene or being acquainted with the victim of the crime, or even denial of the defendant was at the scene. Acts are also classified as a form of omission if they are inconsistent with the accused's innocence. Acts such as trying to escape detection of arrest or hide a crime or omission may be introduced against the accused at the trial.